Good evening. My name is Matt Leopold. I'm the General Counsel of the U.S. Environmental Protection Agency, and I have the distinct privilege to introduce our panelists tonight. First, our moderator for this evening is the Honorable Judge Gregory G. Katsas. Judge Katsas was appointed to the D.C. Circuit by President Trump in December 2017. He graduated from Princeton University and Harvard Law School, where he was an executive director on the Harvard Law Review. Between 1989 and 1992, he served as law clerk to Judge Edward Becker on the Third Circuit, and then Judge Clarence Thomas on the D.C. Circuit, and then to Justice Thomas on the U.S. Supreme Court. Between 1992 and 2001, he was an associate and then partner in the Washington office of Jones Day, where he specialized in appellate and complex civil litigation. Between 2001 and 2009, he served in many senior positions in the Justice Department, including Assistant Attorney General for the Civil Division and as Acting Associate Attorney General. In 2009, he returned to Jones Day, and from January to December 2017, he served as Deputy Assistant to the President and Deputy Counsel to the President. Before joining the bench, Judge Katsas argued more than 75 appeals, including 3 cases in the Supreme Court, 13 cases in the D.C. Circuit, and cases in every other federal circuit. And importantly to this audience, Judge Katsas is a member of the Florida Bar and an honorary Floridian. Please. He spent many years litigating cases in our state and is well known by many in this room. Please join me in welcoming Judge Katsas. Our first panelist tonight is the U.S. Secretary of Labor, Alexander Acosta. Please. President Trump nominated Alex Acosta to be the Secretary of Labor, the 27th Secretary of Labor, and he was sworn in on April 28, 2017. Secretary Acosta is the son of Cuban refugees, a native of Miami and first-generation college graduate. He earned his undergraduate and law degrees from Harvard University. Following law school, he worked as a law clerk for Justice Samuel Alito and at the U.S. Court of Appeals for the Third Circuit. Then he worked at the law firm of Kirkland & Ellis and went on to teach at George Mason University's Antonin Scalia School of Law. Secretary Acosta had served in 3 presidentially appointed and Senate-confirmed positions. In 2002, he was appointed to serve as a member of the National Labor Relations Board, where he participated or authored more than 125 opinions. In 2003, he was appointed Assistant Attorney General for the Civil Rights Division at the Department of Justice, and from 2005 to 2009, he served as U.S. Attorney for the Southern District of Florida. More recently, Secretary Acosta served as the Dean of FIU College of Law. He's been named one of the nation's 50 most influential Hispanics by Hispanic Business Magazine, and he was also named to the 100 most influential individuals in business ethics in 2008. Please join me in welcoming a truly distinguished Floridian, Secretary Alex Acosta. And finally tonight, I have the unique privilege of introducing my boss, Administrator Scott Pruitt of the EPA. Scott Pruitt was confirmed as the 14th Administrator of the U.S. Environmental Protection Agency in 2017. Since the beginning of his tenure, the Administrator has been committed to ensuring EPA gets back to the basics of managing and protecting our environment by engaging with state, local, and tribal partners to create regulatory certainty and enhance economic growth. Administrator Pruitt has spearheaded over 24 significant regulatory reforms, including actions to rescind the so-called Clean Power Plan and the 2015 Waters of the United States Rule. All told, EPA has issued more deregulatory actions than any other federal agency in the first year of the Trump presidency. Please. The Administrator also makes it a priority to get out of Washington and into communities across the country and he embarked on a state action tour where he's visited nearly 30 states over his first year to meet directly with stakeholders that were often ignored by the prior administration. The administrator's other significant accomplishments in year one include reforming EPA's scientific advisory boards to ensure geographic diversity and integrity, ending the agency's sue and settle practices, and working with President Trump to withdraw the Paris Accord. Prior to serving in the Trump administration, the administrator served as Attorney General of Oklahoma, where he became a national leader through a career of advocating to keep power in the hands of hardworking Americans. He served 8 years in the Oklahoma State Senate, and he co-owned Oklahoma's AAA minor league baseball affiliate. He also played baseball for the University of Kentucky, earned a degree from Georgetown College and a law degree from University of Tulsa. He and his wife, Marlon, have been married 27 years and proudly raised their 2 children in Tulsa. Please welcome my boss, Administrator Scott Pruitt.
It's a great pleasure to be here with 2 very distinguished former colleagues of mine from the Trump administration. So let's just dive right in. And let's start with some basic principles. Perhaps none is more basic than what General Bondi mentioned, the rule of law. You all are executive branch officials or policymakers. On the one hand, you have tremendous powers and tremendous responsibilities to vigorously use federal power for the benefit of the government. On the other hand, you're both lawyers, and you understand the limits, law enforcement limits. Could you just describe for us how your training and perspective as a lawyer impacts how you go about your job as a policymaker and decision maker in the executive branch?
Do we need to do it out there?
Sure, okay. It's, Attorney General Bondi said something I thought was very meaningful. When she talked about the rule of law, she said, you start off by being a prosecutor, then you realize that it is your obligation to protect the rule of law. And I love that phrase because when a government official takes an oath, they take an oath to the Constitution, to defend the Constitution. That's really to defend the rule of law, to protect the rule of law. And so for a judge, that means not writing personal policy preference into law. But for an executive branch official, that's also incredibly meaningful because if you look at my agency, the Department of Labor, over the last several years, there are a number of fundamental changes to our legal system that were made by guidance documents. And one of the dangers is when you think about guidance documents, some are formal guidances, but others are changes in administrative manuals, in sort of how cases are supervised. It is actually quite difficult to gather all the unofficial changes that happen, these sub-regulatory changes, because they can happen pretty much in the dead of night. And so as executive branch officials, as policy officials, something that I think is critical is that we recognize within the bounds of what is set up by Congress, we exercise discretion. But even we, as executive branch officials, are not free to rewrite the laws. And so I'll give some examples. When I started as secretary, there was something called a joint employer guidance. And what that said is that a company can become a joint employer with another company if they engage in certain sort of shared practices. And it's interesting because Microsoft wrote an amicus brief challenging this in court. And what Microsoft said was, we believe that it's important that our suppliers have certain workplace rules because we want them to be good corporate actors. Well, the next thing Microsoft knew is it was being told that it had to bargain with the unions of its suppliers because it was a so-called joint employer. That is not the way the law used to work, right? You had different corporations and you had separation among the corporations. And so here's the challenge as policymakers. We should not, through a pen, change fundamental law any more than a judge. We have a lot more discretion. We implement policy, we enforce the law. Within that, we have broad discretion. We can propose changes to the law. But what I saw in the last 8 years of sub-regulatory changes is incredibly dangerous to the concept of rule of law, to protecting the rule of law. And something that I think we have to keep in mind is if we use the same tactics, then over time the American public will come to believe that that is okay and that that is right. And that will erode the rule of law.
Well, good evening to you, General Body. It's good to see you. I see Leonard here too. Good to see you, Leonard, as well. And it's great to be with you. Matt introducing, saying that we've accomplished the regulatory reform and all the regulatory action that we've seen last year. We had plenty of opportunity. So there's continues to be plenty of opportunity because the EPA really was the poster child, frankly, of an agency that would abuse rule of law. In fact, when I began my journey at the agency, the very first day on the job, I addressed the entire agency and I said, we're going to operate by 3 principles: rule of law, process, and federalism. And the rule of law component that I highlighted for the agency is so important because regulatory certainty, regulatory confidence is something that's been lacking for the last decade or so, where we've had statutes like Section 111 of the Clean Air Act or the definition of WOTUS under the Clean Water Act, where the agency has taken actions and provided elastic type of definitions, reimagined authority, if you will, under the Clean Water Act or the Clean Air Act, and then passed or adopted these regulations. And what happens? You have those that are regulated look at the rule and they look at the statute and they say, what's expected of me? I have no idea what to do, and they don't know how to allocate resources. And so that's what creates all the paralysis and uncertainty in the marketplace. So one of the things we're doing, it's often been described as deregulation. Frankly, at its core, it's not deregulation. We're wiping the deck clean of deficient rules like WOTUS and CPP and ELG and CCR and all these other alphabet rules that we deal with. And we're really getting rid of those and doing what? Providing substitute definitions, substitute rules that are tethered to the statute, that provide confidence to the folks that are regulated. And as Matt indicated, as we engage in rulemaking, we're doing it the old-fashioned way, pursuant to the APA. Where you actually propose a rule, and you take comment, you respond to the comment, and you finalize it. That thing that Congress told us to do, as opposed to that sue and settle practice, where Sierra Club or NRDC or another group walks in and they sue us in California and they walk into a courtroom, Judge, I'm sorry, they walk into a courtroom and say, let's cut a deal, and then they package or cabin this rulemaking in a consent decree and then go to every state in the country and say, thou shalt. Now, I don't know where that is in the APA, and I don't know how that's proper rulemaking, but that's what's been going on for several years at our agency. And as Matt indicated, several months ago, we ended the sue and settle practice. I sent a memo across the agency and said, no longer are we going to do sue and settle. So this process, this thing of rule of law, and this thing of, they're not academic, they're not legal, they're practical. They matter in how we do business. And frankly, both Alex and I are at agencies where we have plenty of opportunity to get things right, and we have enough to say grace over. So it's an exciting time to be serving.
Let me, if I could, I don't mean to, but I think Scott brought up a very important point, which is certainty. If a company is going to invest, it needs to know that the government is not going to render its investment worthless a year from now or 2 years from now by changing the rules of the road. And that really matters. It matters in terms of, do we bring investment back into this nation or not? That matters in terms of, do jobs get created? Because if a company doesn't know whether it can set up a Boeing factory and what the rules are going to be, it won't do it. And then it won't create the jobs, and it won't add to the economy. So this isn't just, let's deregulate and provide certainty because we think it's a good idea. It is because it changes lives. And so if you look at so much that has happened, President Trump has said 22-1 in terms of deregulatory actions. Let's talk about what those are. In the environmental area, they are many, they are well known. In the labor space, the joint employer doctrine has been rescinded. The independent contractor doctrine has been rescinded. Overtime rules are being rewritten. They were struck down by courts. Tip credit rules were struck down by courts. They are being reconsidered. You can go on in each of our fields, and it's not a theoretical exercise. It means certainty, which means jobs, which means a stronger economy, and that is good for America.
Good first question. That's a good first question.
You're up.
Good first question.
Both of you, I know, work closely with my former boss, Don McGahn, White House counsel. Two of his favorite themes to preach to that office. One, sort of building on the rule of law point, is that the law has to bind not only the regulated parties, but also the agencies. And another sort of separate idea from rule of law, we all like law, but we also all like freedom. And he says that deregulation, less law on regulated parties, is really important to expand the zone of individual liberty. Any of you like to give your thoughts on either of those?
Well, I think, as far as our responsibilities, fundamentally my job is to administer statutes. I mean, that's what we do at the agency. And so there's a lot of focus on jurisdiction. There's a lot of focus on scope and authority. And where the agency's got into trouble the last several years is filling in the blank, as we just talked about. But I think what is often not recognized within the environmental energy space is the exposure we have to lawsuits where we're compelled to regulate and compelled to respond if we're not trying to provide clarity around whatever statute it is from EPCA to CERCLA across the board. And so I think one of the things that Congress really should be looking at is standing with respect to some of these groups that are bringing lawsuits against the U.S. government, because they truly have set the priorities around many of the areas that we regulate the last several years. And so speaking of the regulated, trying to have less regulation and industry, understanding what's expected of them, we create uncertainty at times because of these 30-party lawsuits. So there is an issue around that I think has to be addressed. It was mentioned earlier, with respect to Matt's introduction, some of the things we've tried to do to incorporate more diversity in experts that we're considering at the agency as we do rulemaking. We have many advisory committees, science advisory committees, the Board of Scientific Counselors, the Clean Air Science Advisory Committee, BOSC, and those types of advisory committees. They're populated by scientists that are supposed to be providing independent counsel to us. And largely, they've not been geographically representative of the country. So when you look at Utah, the second most dry state in the country, versus Minnesota, which is not the second most dry state in the country, we don't have a diverse viewpoint from a scientific perspective. So we have reorganized those committees in a substantial way to address a lot of what we just said about participation and certainty with industry. We brought those scientists in and said, look, we're going to get folks from the West, from all different regions of the country, but here's the kicker. If you receive a grant from the agency, you can also serve in an advisory capacity, because we had scientists on those advisory committees just in the last 3 years had received $77 million in grants, and were providing quote-unquote independent counsel to me on the ozone rule, on the passage of certain rules. So we, along with that other memo in Sue and Settle, I issued a memo saying that choose this day kind of thing. You're either going to get the grant or you're going to serve as on the advisory committee, but you're not going to do both. Of course, the New York Times said that we fired scientists, but we didn't. We just simply went to those and said, look, you can serve, we want your counsel, but you can't get both the grant and serve in that capacity. That's the kind of accountability, in my view, that we need at our agency, and I think across a number of agencies, Alex, as far as the kind of these FACA panels and rest that are helping us make decisions that impact industry day to day in the business and in the states across the country.
I can't agree more, and let me just say that you mentioned Don McGahn, and we sit up here and we do these interviews and we attend events, and behind us there are some incredible individuals. Don McGahn is an incredible individual. The Federalist Society honored him by having him give one of the, I think it was the Barbara Olson lecture. And he's a real hero. And for those of you that don't know him, he is someone that you really should think about, because he is, in his heart, he understands the concept of rule of law and has deeply, deeply worked to effectuate that through the federal judiciary in his roles in the White House. And so first I want to acknowledge Don and the roles that he has played. Moving on to your questions, you know, you're right. So the law needs to bind the agencies, and that's the point I was trying to make, in that we need to act, as Scott said, through the rulemaking process, not through sub-regulatory guidance. We need to act in accordance with the law. And sometimes that's difficult, and I'll give a very specific example that's impacting Florida: occupational licenses. Currently, there are about 1,100 professions that are licensed throughout the United States. It used to be that the occupational licenses was rare. Now, almost 1 in 3 Americans need a license to do something real simple, work. From dog walking in New York, to fortune telling in Maryland, to working at lens crafters in Nevada, to giving dietary advice here in Florida. And so there's a really interesting case that I've come across where a military spouse moved to Florida and was giving dietary advice. It wasn't licensed, or maybe she had a California license, or it wasn't licensed in Florida. And she started giving dietary advice, and now she's being fined and sued by the state of Florida. And you've got to start wondering, you know, the military serviceman moves from state to state. Is it really fair for the military spouse to have to give up his or her profession every time the military service person moves? And that's happening right here in Florida, and it's happening in this state. And it's so tempting to try to pass some federal law to preempt all that. And it's so tempting to try to come up with ideas and regulations to preempt all that, because it just bothers me in a real fundamental way. That's not the way America should work. But that's not what we stand for, and we have to resist that temptation. So one of the things that we're doing is we're working with governors to create multi-state compacts. We're trying to reduce the occupational licensing. And that's, I think, the right role of a limited government, one that respects the rights of the states to regulate certain things like occupational licensing. So that was the first half of the question. The second half of the question is, you know, as you sort of look out and say, how do you approach policymaking and rulemaking? What do you want to do? And so things like sue and settle, they're just wrong. It again undermines the role of limited government. And so here's how this impacts freedom. And I want to make an observation. President Trump has said 22 rules to 1. And this is all the deregulatory financial calculations around all these rules. But how many times have you all seen someone say, we are changing this rule because it impacts liberty? And it's a really interesting question, because in government, there is an office called OIRA, the Office of, help me out here, what's OIRA stand for? Information and...
I'm glad I asked you.
Information and what? Reform.
I didn't know it was going to be a quiz.
OIRA. We all have the acronyms. And they sort of do the cost-benefit analysis for rules. And they are a very good and crucial office. And then there are executive orders that require cost-benefit analysis. And here's one of the concerns that I have, that in this process, we forget about freedom. Because it's very easy to quantify costs and benefits. It's very easy to say, this is the cost of this rule, this is the benefit of this rule. But a lot of rules that limit freedom are bad not because of the cost they impose in society, but they're bad because it restricts freedom. And so as we look at the costs and benefits, and as we work with OMB and OIRA and these agencies that really take a deep dive into the rulemaking process, I also think it's important that we not try to over-quantify this. Because a lot of simple rules shouldn't be on the books, not because of the costs and dollars that they impose on society, but because of the restrictions on individual freedoms that they impose. And that qualitative analysis is really difficult. And so I think it gets avoided because you've got to ask things about, freedom versus security versus, standards of living. And those are much harder to talk about, but they're oh so important. So in my space, deregulation for freedom's sake really matters. And I think as we look at the regulatory burdens out there, we can't just become human calculators that look at costs and benefits. We also have to look at the impact on everyday lives and on freedom.
Let's talk for a little bit about your respective backgrounds. So, Administrator Pruitt, a lot of folks think there's a basic cultural divide in the country between inside the Beltway and everywhere else. You grew up in Kentucky. Your professional home was in Oklahoma. To what extent did you face culture shock when you came inside the Beltway for, I think, the first time, at least professionally?
Well, the good news is that we got the chance to interact with the agency over about 5 to 6 years because General Bondi and I were suing them so much. So, and so we got a chance to get inside the Beltway and deal with that, right, General Bondi? But I think that it's good with respect to our perspective, coming from a state attorney general and the issues that I dealt with for 6+ years, these rule of law issues, these process issues that responded to the overreach, the use of statutes in an improper fashion by the various agencies. So it was something I felt like I was equipped to do, and I felt like the team I had in place was equipped to do, and we've had a busy year in that regard. But I think as we think about how we go forward from here, one of the things I've tried to emphasize, and I talked about it in my first comment, is the importance of partnering with the states. When you think about the environmental statutes we have at the federal level, when Congress adopted them in the 1970s, they were very prescriptive. They understood that a one-size-fits-all approach with respect to air quality, water quality, these very statutes is very, very challenging. And they gave specific prescriptive authority to states across the country, some permitting, but other types of authority to ensure progress in each of these areas. And what happened in the last several years is truly a displacement of that. You had a federal government that ignored that and took coercive action to displace state authority. To give you an example, President Bush I, President Clinton, and President Bush II, 3 presidential administrations, issued approximately 5 federal implementation plans during their tenure as president. President Obama issued over 50. And so that's an example of an administration that looks at authority under a statute and says, we are going to use coercive action to displace and become paternalistic with respect to states and their role in this space, and it didn't achieve good outcomes for the environment. To give you an example, attainment with respect to air quality in this country, when President Obama left office, 40% of the country lived in areas that didn't meet air quality standards, about 120 million people. We had more Superfund sites when President Obama left office than when he came in. We had Flint, Michigan, and Gold King, Colorado with respect to water. I mean, if you look across the portfolio of environmental advancement during the time of the Obama administration, it's very, very, very unimpressive because of the steps that were taken through rulemaking that were stayed. People get all upset and they get concerned about us withdrawing the Clean Power Plan. Why are people concerned about that? The U.S. Supreme Court issued a stay. It's never gone into effect. It needs to be cleaned up. Same thing with WOTUS. So these steps that the previous administration took through rulemaking that have been challenged and stayed by the courts, and then we have steps taken practically to displace state authority, have not yielded good outcomes for the environment. So what I've tried to focus upon at the agency is restoring the notion of getting back to the basics. I call it EPA originalism. You know, let's look at our scope of responsibility and do the job before us. Let's actually show results and measure those results and hold each other accountable. To give you an example, this week, there's a site in Westlake, Missouri, a Superfund site, has uranium from the Manhattan Project. Discovered in 1970, was listed on the national priority list in 1990. When I came into this position, 27 years later, last year, the agency had not made a decision on how to clean up the site, excavate or cap. Not clean it up, not remediate, just make a decision. Do we excavate or do we cap? 27 years. I went to St. Louis, Missouri, and I said, we're going to give you an answer about within 6 months. We released that answer yesterday. The people in St. Louis are absolutely thankful that they now have clarity. We're going to clean up the uranium on that site within 5 years. It's going to cost $236 million. Republic's going to pay for it because they're the responsible party. And the citizens in that area are saying, finally, someone's showing leadership to actually serve the community here and get progress with respect to the environment. You know, that's the kind of work that we have to do as an agency, and then do the fundamentals, rule of law, process, and federalism well. And you know what's going to happen? Better outcomes than the past administration. I mean, people looked at the Obama administration as the environmental savior. I don't know why. You know, this administration is going to get it right. And this president, what I love about this president, what I love about what he said Tuesday night in the State of the Union, he looked back on 17 and said, here's what we've got done. Here's how it's making a difference. Here's what we're going to get done in 2018. People look at this president, and they look at Alex, and they look at me, and they look at other members that serve this president, and guess what they're focused upon? Getting things done. Actually doing the work before us. And that's what's so exciting about serving at this time, because we're kind of getting back into the rhythm, if you will, of what we should be doing, as opposed to all the things we've seen in the last decade or so. So it's exciting. It's exciting, and I think there's some optimism out there.
Alex, you spoke eloquently about individual liberty and freedom. Your parents immigrated from Cuba, a country which has much less of that than we take for granted. How did their experience inform how you look at the world and go about your job?
So this week was a pretty incredible week because not too long ago, Scott and I were in the House chamber at the State of the Union. I thought it was an incredible speech. I thought it was an uplifting speech, an optimistic speech, one where the president really said, let's go forward together, and laid some possible deals that could be made on the table. And someone asked me about it, and it struck me afterwards. My parents emigrated from Cuba. They didn't go to college. And I'm in the second row of the State of the Union. That's not about me. That is a statement about this nation.
Right.
And it is a statement about what freedom and opportunity mean and why we need to value a system that rewards those that take risks and that provides opportunity. And, you know, Greg, you asked about this divide and Washington versus in the Beltway versus outside the Beltway. And something I very much try to do is get outside of Washington. About once a week, I travel somewhere. And when I travel, I'll talk to a group. I try to do a factory tour, maybe talk to some folks. And for me, that is really inspiring because those are real Americans that are building the nation.
but they also come up with really great ideas. And I'll give you an example of what you hear about outside the Beltway versus inside the Beltway. And here's a question that I have for you all, and go with me for a second. How many of you have ever been in a hospital bed? Pretty much everyone. The Department of Labor considers the operation of a hospital bed inherently dangerous. And I found this out because I believe that you need to start teaching practical skills in high school. There once was something called shop. You all remember that? And we've got a lot of folks graduating with a lot of knowledge, but not a lot of work-ready skills. And so I started asking folks, why aren't you teaching shop? And some of them said, because of you. And I'm like, what do you mean? Well, it turns out that a high school cannot teach someone how to be a nurse's assistant because of DOL regs, which I've asked to be reconsidered as an aside. But getting out of Washington matters. And for me, this is an incredibly important calling because we have to preserve opportunity for the next generation so that the next generation of folks can be at that State of the Union in the second row. And that's
Another basic principle for this group is federalism, which is, of course, maintaining the proper balance between the state and federal government. That was a signature issue of yours. You held state elective office as state senator, state AG. Could you tell us about some of your efforts in suing the federal government in various areas to try to maintain that proper balance?
Well, I think I mentioned this earlier with respect to federalism. It's something that is very, very important to how we achieve good outcomes as an agency. And historically, it's been very, very important. But over the last several years, it hasn't. When I came into this position, to give you an example, there were 700 state implementation plans. Plans that states had invested money, resources, obviously expertise, to develop a process by which we'd improve air quality. You know, whatever state it would be, 700 of those that were sitting on a shelf in Washington, D.C., that the EPA had not lifted a finger to process those and actually work with those states to achieve better outcomes. I mean, that is not the way that you should do business. 2 days after I was sworn in this position, Sunday morning, I had the Western Governors Association in, about 20 governors, Democrats and Republicans, and I spent time with them, and they told me stories from the financial assurances rule to WOTUS, to Clean Air Act, SIP issues, and federal implementation plans and the rest on all the things that we've done over the last several years, really trying to displace and or be paternalistic over states with respect to their role under each of these statutes. So when you look at when you think about federalism with respect to the EPA, it is essential to how we do business. We have many delegated programs. To give you an idea, about $8 billion budget we have, 25% of that budget goes to the states to implement programs under our respective statutes. So it is not only important practically, there's money that's delegated to the states, appropriated to the states, and it's a partnership over the years. And I just want to emphasize something to you. I think what's been lacking, because federalism has been really not paid much attention to, is this lack of a partnership. States matter. States care. Governors at the state level, they want to improve air quality. They want to improve the environment and the outcomes with the environment, but they also want to grow jobs. And one of the things that I think is the most challenging thing we deal with at the agency and across the country today is what is true environmentalism? When you think about that, what does it mean to be a true environmentalist? In the last several years, the answer has been prohibition. Though we've been blessed with all these natural resources, we shouldn't use them to feed the world and power the world. Keep it in the ground, put up fences, do not touch. We've never been there as a country, by the way. We've always been about recognizing the blessings we've received and our responsibility, and I want to emphasize that word, our responsibility to manage those resources with stewardship principles in mind for future generations. Since 1980, we've reduced those pollutants that we regulate under the Clean Air Act by over 65%. We've also grown our GDP substantially. We can do both. You know this because you've traveled internationally. We do it better than anybody in the world at growing an economy and being respectful and stewardship-minded toward our environment. We have nothing to be apologetic about as a country. In the last several years, there was an attitude that drove regulation. The EPA was weaponized against certain sectors of our economy, which is amazing in and of itself. And we've come in, the president's come in, and said we're going to end that type of practice. We're going to de-weaponize, if you will, disarm the agency against certain sectors of our economy and recognize once again that we can partner with them, that we can work with industry, that we can work with states, that we can partner and achieve good outcomes. Look, why should we, as an agency, presume that those in industry are automatically going to do what's wrong with respect to the environment? There is this noble principle that we have, and a very practical principle in this country called self-governance. And private property and ownership of property drives what? Stewardship of property. I was in Tallahassee earlier today at a farm before I arrived here, and there was a young man named David. As I arrived at this farm, he had Make America Great hat on as he met me at the farm, and it was amazing to see the generations from granddad to dad to David. Farmers and ranchers here in Florida recognizing that David is going to pass it on in the future, and we should be what? Good stewards of our land today. We should recognize that and celebrate that as a country and recognize we can work together to achieve good outcomes. So it's so essential. These federalism principles are not just academic and legal. They are practical to how we achieve good outcomes as a country. And I would say to you, as we go out and have the discussion in 2018, I hope that we can have a discussion about what is true environmentalism. And it's stewardship, not prohibition. And we need to recognize that and know we can do better than having to choose between jobs, growth, and protecting the environment as we go forward into 18 and beyond.
Alex, your last job before coming into the cabinet was as a law school dean. Could you tell us a little bit about how that experience shaped your views, and could you also talk a little bit about whether you think law schools are doing a good job? I know a lot of people have concern that they're out of whack relative to the country and maybe not the most tolerant places in the world anymore.
So, gladly. I had the opportunity, Governor Scott invited me back here to talk to all the university presidents and trustees in Florida. And I'll give you the 3-minute synopsis of what I told them, because I think it really matters. We spend federally $114 billion at least on education. And that does not include all the tuition that everyone pays. And that tuition's a lot of money, and it's a lot of blood, sweat, and future tears when they go to pay it back. And so Florida is doing fabulously well. Among the 10 large states, it is number 2. The governor says that's not good enough, he wants to be number 1, but it's number 2. So what that means is that 68% of students that begin college in the Florida State University system graduate within not 4 years, but 6 years. How many of you knew that we now measure college graduation in terms of 6 years? Because so few graduate within 4. Now, of those 68%, and I'm working off memory here, so I could be off by 1 or 2, about 63% go on to find a job that pays $25,000 or more within a year. So, for simplicity's sake, 2/3 times 2/3 is 4/9. Less than half the kids that start college will finish within 6 years and get a job that pays $25,000 or more. And that is the second best system among the large states. So the question becomes why? And this is something that I think about because I think labor and the labor shortages that we have are impacted by higher education. And so the question becomes why? Why do we have, literally in the United States today, more than 6 million open jobs that we cannot fill, and employers are saying we are desperate to hire, so much so that we have to bring in folks from abroad because we don't have the skills here? And so the question becomes the why. And so if you take a step back, I find it really interesting. So I'm not going to put anyone on the spot. Well, maybe I will. Anyone want to be put on the spot here? Anyone want to tell me what the enrollment rate is for the university that they went to here in Florida? Someone, please, come on. University of Florida, what's the enrollment rate? Crowd. 52,000. 52,000. How many graduate? Does anyone have any idea?
12,000.
Are you guessing?
Yes.
Guessing. Isn't it interesting that you all know how many enroll at University of Florida and Florida State, but not how many graduate? How many of those get jobs? No business would judge itself by how many customers walk through the door. And if they did, that CEO would be fired by the board in an instant. I like to say there are two entities that judge themselves by inputs: higher education by enrollment, and government by how much it spends. But we don't judge ourselves by outputs. It's not, do we have a program that works, but rather do we have a program that's $1 billion or $1.5 billion? Do we have a university system that graduates kids and gets jobs? Or do we have a university system that brings in a lot of endowment money and that brings in high enrollments? And I think that's a real fundamental disservice. And so one of my takeaways is that we desperately need to look at our educational system. And we need to marry up our educational system with workforce. So I've been talking a lot about what I call demand-driven education. Education that looks at the skills that the workforce is demanding. And I'll give you all an example. Anyone here do a semester abroad? Okay. Think about how much you learned in that semester abroad, how much you studied, all that knowledge you acquired, right?
It looks like that much, maybe.
Yeah? Why can't someone do a semester at a police academy? If someone's majoring in criminal justice and they can go do a semester abroad, why can't they go do a semester at a police academy where they learn the policing skills that will help them get a job? And why can't they do that for credit, right? But instead, they're being forced to take on debt and graduate. And I think about this, I give this example because I know one young man that wanted to be a police officer, but ended up as a security guard because after he majored in criminal justice, he didn't have the policing skills. There is no reason you can't do a semester at police academy. Medical schools teach you how to suture, and they teach you anatomy. And so it's not the case that it's anti-intellectual, because doctors are certainly a learned profession. And so applying it to law schools, I would say that we also need to think deeply about whether or not law schools should encourage semesters in practice, whether they should encourage full semester internships with DC Circuit judges.
Sounds good.
And do all that for practice, because I think that would change the profession and the education.
Let's talk about some of the high-profile items that you all have been involved in. Administrator Pruitt, the president's probably most important decision in the environmental area that he made himself was to withdraw from the Paris Accords. You and I were in some very
courageous decision.
You and I were in some spirited meetings in the Roosevelt Room. I won't ask you
They
to
were great, weren't they?
go into the internal deliberations, but the decision was what it was, so why don't you tell us a little bit about what that means going forward and why you think it was the right decision.
I do want to say, I mean, that first and foremost, it was a courageous decision. The president has talked consistently about putting America first, and that's a great example of putting America first. Because when you think about the Paris Accord, the Paris Agreement, many folks looked at that and said, in fact, many folks argued, there are no obligations there. I mean, the 26 to 28% targets that were set, they're not obligatory. What's the concern? Just simply don't do it if you don't want to do it. That was never the case. In fact, speaking of law school, Alex, there were law review articles that were being drafted in the summer of 2016 in anticipation of Hillary being elected president and of environmental groups suing the EPA to compel regulation to achieve the 26 to 28% targets under Section 115 of the Clean Air Act. Because no one knows this. The Clean Power Plan that the previous administration adopted fell 40% short of the targets set in Paris. So the president was right from a legal perspective, from a exposure perspective, just very practically to get out of Paris. But beyond that, it was a bad business deal for this country. You know, we go to Paris and China and India say what? Yeah, we'll sign this deal. We'll start reducing our emissions in the year 2030. And oh, by the way, India will condition our reduction on receiving $2.5 trillion in aid from whom? The United States. And so we go to Paris, we're apologetic about all the steps that we've taken as a country. We've reduced our carbon footprint in this country by almost 20% from the years 2000 and 2014. We are leading the world in reducing our CO2 footprint, largely through innovation and technology, not government mandate. This country has nothing to be apologetic about with respect to that issue, but yet we went to Paris and apologized. So the president standing in the Rose Garden, saying to the rest of the world, we're not going to be taken advantage of through those types of agreement was the right thing to do. And the reason there's been such a backlash is because it put us at an economic disadvantage. What was really interesting, a week after we made the decision, or he made the decision, and we had spent time, and it was announced in the Rose Garden, I was at my meeting with the G7 in Italy. And I was meeting with my counterparts there in Italy. And the first couple of folks who came in, they were bilateral discussions. They were rather paternalistic in the communication. We were so disappointed in the United States. And they would go through these types of communications. And about the third, when I was trying to act in a diplomatic way and very listening and responding as best I could, about the third meeting, I'd had kind of enough. And so I don't know what country it was, but I took our sheet and I put it on the table. And I had all of the stats of what we've achieved as far as CO2 reduction over the years. And when they brought it up, I said, you know, let's see what you've done compared to these numbers. And they went silent. This country is led through action, not through words. The past administration was all hat, no cattle. Now, for those of you who aren't from Oklahoma or Texas, all hat, no cattle means you're kind of full of bluster. You know, you kind of just talk about things, you don't do very much. The past administration talked a lot, they did very little. This administration is doing a lot. And Paris was something that I'm so glad we dealt with it. The president showed tremendous fortitude and courage. He did the right thing. And he also said to the rest of the world, we're going to remain engaged, but we're going to do it with an America First approach to how we do these issues. And he should be very much commended for his leadership in saying no to the Paris Accord.
One of the justifications for Paris put forward by the other side was to help get us closer to satisfying Clean Power Plan. That's somewhat moot, since one thing you're working on is rescinding the Clean Power Plan. Could you talk about that?
Yeah, unprecedented. The only rule that I'm aware of that the U.S. Supreme Court intervened during the pendency of litigation to stay the rule. And largely because Justice Scalia and others on the court felt that, because the EPA kind of bragged that they had passed some rules previously, that by the time it made the Supreme Court, they had already achieved their objective practically, causing utility companies to shift generation of power. And so they intervened and issued a stay against that Clean Power Plan. You know, they take the Section 111 of the Clean Air Act and say, our theory of the best system of emission reduction is we're going to coerce the states and utility companies across the country to shift how they generate electricity from fossil fuels to renewables. And these countries who think that they can really power a grid to serve their people on renewables only are just simply living in a fanciful place. It's intermittent power. I mean, renewables should complement our grid. They shouldn't be there to serve the baseload energy of our power grid. We need a diversity of fuel, from natural gas to oil to hydro to nuclear, across the spectrum of renewables, to make sure that we have a stable, reliable, cost-effective grid. And countries who are making decisions based upon political objectives as opposed to practical objectives are going to pay the price. This president has sent a message that the war on coal is over, the business of the EPA using its authority to coerce that type of decision, like the Clean Power Plan is over, and we're going to get back in the business of operating within the text of the statute. Now, we're getting rid of the CPP, as you know, and that process is ongoing. But we're also asking the question. We're soliciting comment. We're doing our job, asking those in the marketplace, what do you think the authority is, if anything, with respect to regulation of power generation in that space and CO2? And we're soliciting comment now. So we're doing our job, but we're getting rid of the deficient rule. But we're also sending a message to utility companies in states across the country that the days of us using our authority to coerce decisions in the marketplace on how we generate electricity are over. And that's a good thing for this country and a good thing for our economy.
Let me if I could amplify something that the administrator said that I think is incredibly important. The president flew to Davos, and a lot of folks said, why? We thought he was against that, right? About globalism. But he flew there to make a very important point, and something that I think reflects what the administrator said. America first does not mean America alone. Every country, he made clear, should act in its own interests. And every leader should act in the interests of that country. The problem is when the leaders of China and France and Germany act in their interests, and the United States says, we're not acting in the interest of ours, we're going to help all those people. And that is not the right policy. That is not our policy, and that is a fundamental distinction. And so you see that with the Paris Accords. You see that with trade. We get the question all the time, why aren't you for free trade? We are for free trade that is fair, right? But if one nation heavily subsidizes their industries so that they can sell products at a lower rate, that's not really fair, and so it can't be truly free. And so it is not that we are antagonistic, because the president made very clear, we want other nations to invest in the United States. We are, in his words, open for business. We've got lower tax rates now. We've got more regulatory stability now. We are open for business. But we're not going to turn around and say the rest of the world can make their economies grow on the backs of Americans. And that's what Scott has done that is so important. He has said, Americans will come first. And that, I think, is a fundamental shift in policy at the EPA and on trade and on so many other issues.
If I could add something here. Thanks, Alex. I think as a nation, what we ought to be focused upon is exporting the innovation and technology that we have deployed over the last several years to improve air quality and water quality and work with these nations. It is naive for us to think that China and India are not going to use the natural resources they possess to grow an economy, to develop an economy. They're going to do it. What we should work with them to achieve is how to do that best through emission reduction, through innovation and technology, and we ought to work in that regard. So there is a partnership that matters, but to go to a place like Paris or anywhere else and say we're going to agree to arbitrary percentages to penalize our own economy while the rest of the world doesn't have to meet those percentages is really reflective of what Alex said about fair, free trade. That's not an America First approach, and it puts us at a disadvantage, and this president is absolutely committed to making sure that doesn't happen in his administration. So that's a good thing.
I'm told that you have to go, so let's.
Who told you?
Your lawyer.
Okay, all right. He's a good one. That's you.
Let's give Administrator Pruitt a
Thank you.
big round of applause. Thanks.
We had a good time.
That's great.
Good to see you. Thank you. Good to see you. You staying? Give me a hug, buddy. Give me a hug. Good to see you. Good to see you, bud. How you doing? Good to see you. Good to see you. Good to see you. Good to see you. Likewise.
Should we just finish up on some of the labor?
You've got me all for the rest of the night, so we'll be here till 11.
So, just I was, as you know, I was on the Justice Department landing team for the transition, and one of the things we did was look at the litigation docket of DOJ to try to figure out what were the big pending cases that the incoming administration would have to pay attention to. And it was really sort of shocking, the disproportionate representation on that list of cases arising out of very major...
Before I got there.
Yeah, from the prior administration.
I was trying to be funny, sorry.
They were very active in their last year or so, and so we have the fiduciary rule and the overtime rule and the persuader rule, and one after another. So I'll just, it's an embarrassment of riches. I'll let you pick whatever you want to talk about.
So, you know, I was trying to be funny, but it's actually a very serious issue, and it goes back to where I started about sub-regulatory guidance and changing national policy through guidance or through some rules and not even through law. And so when the judge says it's embarrassment of riches, the truth is overtime rule has now been enjoined by a federal court. Persuader rule was, you know, had all sorts of legal issues. You could go through, and not only were the lawsuits there, but the lawsuits were being lost by the federal government. And they were being lost by the federal government because there was an overreach. And I'll use Persuader as an example. The Persuader rule required that lawyers disclose contacts with their clients even if there was no third-party disclosure. And so to spin that out a little bit, if a client hires you and you walk into the room and represent that client, well, you know, by your very public representation, you're disclosing. And so, you know, it's not that big deal to have to disclose that, you know, to the government, or maybe it is, but it's very different. But the Persuader rule required you to let the government know if you were just hired to give advice behind the scenes. So even the ABA came out and said the Labor Department had gone too far. And we can sort of go down rule by rule by rule. And I think it has to do with a very different view of what the function of a secretary should be, or what the function of a government official should be. And I think given the Federalist Society, this is probably a good place to sort of start to wrap up, which is if someone disagrees with the way things are happening, you go to Congress. But you don't say, I am going to use my regulatory muscle to exact, extract, or force an outcome. That is not respecting liberty, that is not respecting limited government, and that is not respecting the rule of law. You don't settle lawsuits to get a particular outcome. You don't use your enforcement muscle to get a particular outcome. And I think that's a sea change in approach, but a really important sea change because it says that the rule of law is what matters most because that is the fundamental underpinning of our society. And if we lose that, then it just becomes the whim of man. And even if someone thinks that it's the right thing to do, that whim is a very, very scary thing. So I'll give one very specific example. For decades, the department had issued what it called opinion letters. In an opinion letter, someone was able to write in and ask, this is a set of facts. What am I required to do? You see them in taxes. You see them in so many other areas. And my department had stopped issuing them. And the reason is that if you provide an opinion as to what the law requires, and then someone follows what you said the law required, you can't enforce. It becomes a, quote, get out of jail free card was the phrase that was used. Why would you ever want to enforce if they're doing what you think the law requires? Unless you want to use enforcement authority to get some other outcome. And so obviously we have opinion letters back and so many other things. But we are an active client for the Department of Justice. We continue to be an active client. And I think it's sort of reflective of how much we as a society need, how much all of you need to monitor what we do. Because those lawsuits that were brought by Attorney General Bondi and others were the ones that caused the department's rules to be enjoined in court, were the ones that held the department honest and limited the department's discretion to what the law requires. And so those lawsuits and the public vigilance of us truly matters, regardless of administration, because it ensures that we follow our limited role in a system that really needs to elevate liberty and that should use rule of law to protect liberty.
I think we've used our allotted time, so on that optimistic note, please join me in thanking the Secretary of Labor.
We have one final treat to cap off this great evening. It was just 2 years ago, a week from this next Tuesday, that we had the tragic loss of Justice Scalia. And I know for me and probably others in this room, one of the only comforting thoughts I had that day was that Leonard Leo was in Washington, D.C. And we saw over the months after that the incredible impact he had. He was in just the right place for some very important events for our country. Please join me in welcoming the Supreme Court Whisperer, Leonard Leo.
Thank you very much, Jason. Thank you, everyone. You know, it is incredibly inspiring and invigorating to be here with all of you today. You know, looking back, I can remember Lisa Ezel and I from the Federalist Society traveling down to Miami years ago, sitting in this dingy room in a teeny tiny hotel on the South Beach of Miami with a small handful of people, Tom Barber, a couple of others, banging our heads up against the wall trying to figure out how we were going to build a sustainable operation in Florida. And now we're in a ballroom the size of which you could probably have fit that whole hotel in. So that is very exciting. And seeing, you know, Secretary Acosta and, you know, Judge Greg Katsas, we grew up in the Federalist Society as kids. Here they are now helping to steer the ship of state in two of our very important branches. And then, of course, the revolution that we saw, inspired in good part by Scott Pruitt and Pam Bondi and a merry band of state attorneys general who completely transformed the conversation about what it meant to be a state attorney general, to defense of the rule of law and the vanguard against overreach by the federal government. What an incredible transformation in just 10 or 15 years. So few movements in American history move that quickly and grow that fast. But it's a great evening to think about that and to see all of what's gone on here in Florida. We're in a time of amazing opportunity, amazing opportunity. We are seeing the transformation of the federal bench in ways that are going to bolster freedom and federalism more than we've seen, at least in the past decade and maybe longer. As you've heard from Alex Acosta and Scott Pruitt, we have an extraordinary deregulation agenda. This is going to give states like yours, governors like yours, the space to be creative and innovative and entrepreneurial and market-driven, which is really important. So how do we seize this moment? What do we do to take advantage of this amazing opportunity we have before us? Well, first of all, I don't know if you've all noticed, but I think there is a tremendous openness to our ideas. At its core, what we stand for is the idea that the structural constitution, those limits on government power, are inextricably intertwined to the preservation of freedom and human dignity in this country. And that is a message which is beginning to resonate with the American people. You heard parts of that in the President's State of the Union address when he talks about consent of the governed. You heard about it in his inaugural address when he talked about self-government, a way we hadn't heard, perhaps going all the way back to Ronald Reagan. And so there's an openness to these ideas. I think he's presented them in an important way, and I think it's incumbent upon all of us to be those little platoons around the country, as Burke talked about it, to continue that message. Secondly, there's an unprecedented need for talent at the federal level. Some people have answered that call. You saw them up here. But there will be many, many more opportunities to populate the federal government and to try to move that Leviathan in a direction that preserves freedom and personal responsibility and human dignity and free markets and prosperity. Some of you in this room have already answered that call, along with the folks we had up here. I hope others of you will think about it when there are appropriate callings up there in Washington. And I think most importantly, for purposes of this conference this weekend, there are great, exciting possibilities for experimentation at the state level. Experimentation that could not have existed for the 8 years preceding this administration. Ideas and talent are going to be needed for those opportunities for experimentation. And there's a great spark in this room amongst all of you that I think can help to usher that in here in Florida. This is a strong movement. The Florida conservative and libertarian legal movement is a strong movement. You know, when I visited with Rick Scott in 2009, which I think was 2 years before he was governor, I think it was 2 years, you know, we talked a little bit about the judiciary and judges and the rule of law in this state and deregulation. I couldn't have imagined then what the future would hold. Seeing him as governor, seeing all the people around him who are helping to shape policy. This has become such a strong movement in less than 10 years. And I think you're ready for the many opportunities that are ahead of us. And I want to thank you for all you've done to get the state to where it is today. And I want to promise to you that whatever the Federalist Society can do nationally to help you in your efforts here, we stand ready to assist. So thank you. We're indebted to you for your service and for your enthusiasm for our principles and ideals, and we look forward to working with you in the years to come. Thank you.